Abusia eye efikesiem a mitwe ma Manhyia atonensa afre eye AbusuaPanyin Brefo ene ex AbusuaPanyin Tupac ene maame Akosua Bempomaa ena mama China watonensa afre sa mpanimfo ya omo de lumba abusuam se omombra mumbe yi omo ano se eya mamra kwan so ena yedetu eye AbusuaPanyin Kofi wuso enim se fre no AbusuaPanyin Tupac no se amamra kwan so de AbusuaPanyin Brefo ebetumi de ade na mmom enya amamra kwan so a AbusuaPanyin Tupac ebetumi asa di na ade abusia eno no na amankomo bi nso ababetodwa kame ho ne nkwaje nsem ne mu ntwemu embra.
For instance, mini yera secretariat wo ebia obede hu se yera osi obi a o maneba secretariat ebe sign obede hu because there should be record administration secretariat enye sebi tafra chempage so encouragement no mo ye no ho me de minim say bibi sa abekoso but ebia ma bonten bibi na beba bonten minim say definitely there will be an instrument of appointment yera or Asante Kotoko hene say ono oba e wa ma traditional council wa Asante mamu nyina wa ma omu nyina operate in the rightful manner. Obeko traditional council bia no say lawyer na ye clerk ho a na paralegal na ye adwuma ho ebi see that
for the chiefs and I say AbusuaPanyin asem ne yeken
the chiefs asem no bi sa ebi see that
chiefs ne the gazette ne we say no Manhyia ankasa doesn't do but they facilitate
no gazette me can say yera administratively inside yera administration no definitely there will be record be a chair say my appoint you aba sign bibi na ye keep it in a parliament say ye pa MP or sign book no definitely internally bibi side
America said there is that thing but no you would have to be gazetted first and then you send it
and your gazette one some na gazette you be no say on here and your gazette no can say letter
they make an own here
can say I know what to was if you can you no see answer na bet na say
okay
yeah bra me o gazette na say me be o gazette na
right
was omo gazette here the gazette stipulate or a year or my enimina no omo rules ni appointment ni bibia no I think say AbusuaPanyin so no a faster process no so abusua ni nyina agi to say something it becomes a valid a year abusua ni nyina agi atum. In my opinion, I think that is how they do it. But if the court is going to see, say, there should be, say, somebody can confess, say, CS7, and I have friend wa himfi no bano. Unse with the court, no, CS7, by na amamremuno, ye friend wa himfi no aba. Ye two bofo no aba, no abe catcher, no aba himfi, na ohina trans, ni weti o side. Na weti omo de asem no so be ball no side se wa asem ye da na ye yu na asem pabwa ana court no so ye be ma letter no aba na uba na court di wa asem wo ho I think say near council can very right but all can the court no na me patch say near ha ma drink akra ni say eye abusua asem ya hemfi asem no they did no man na hemfi no mo ye ni paper so mo de aba internet so say ye
on say no
obeji atu say ye tunu because only in his mind no man for the right procedure no into say ye tunu
okay unim no where you are getting things wrong they say you want to fuse where's I be confused you want to fuse AbusuaPanyin and chieftaincy into the chieftaincy
no that is not what I'm doing and the difference near far
and to say question is saying
Prestige. I think the new Abema no some more catch on say you see AbusuaPanyin yin go see no court. Abusua ni nyina national it's a traditional
that is exactly what I'm trying to say.
Yeah, it's purely traditional. It's got nothing to do with the courts. Into no means uncle go at the end of court. So yeah, the court when Abusuana tried the traditional essence and they didn't feel said there was justice done to them. Then
they seek the higher authority,
and then the court will decide on it. But I deal with a purely traditional. I can't afford to AbusuaPanyin. It wasn't the right process. traditionally.
It's not also to say a tunu no.
Exactly.
Kens,
Yeah, no,
Kens.
yes, Papa.
On say, when you say AbusuaPanyin 2 no, I could pay more court severally. And you win
Yeah.
one. Akọ Supreme Court crapping.
Okay.
Emma Supreme Court cry actually procedure or some of us to AbusuaPanyin. The AbusuaPanyin 2 there. A court da, a taco da.
No, that's not what I said. Make I say omutu na say AbusuaPanyin feel say the processor fast no was not the right processor. He can decide to refute it. And no na say oh my Ghana no you amamra you dibu my no and traditional we say processes ni no. The constitution sort of looks at it with a certain viewpoint. Say, okay, it's accepted because ansana constitution omudi bu mind dada. So into norm the court court in to me na fe o ma hwe nhyehyɛ a ɛwɔ ebia saa abusuakuo na another tribe another group of people no the way omusisi abusuapanyin ɛne kwan omufa so a omutu omabusuapanyin na they are to the almost guidelines when then they would make any judgment based on those things internet yes abusuapanyin to that yeah the court da but a kwan traditionally you see abusuapanyin to abusuapanyin so no
that's exactly what I'm trying to say.
We say alumba mu de akoye adehye abusua no enya abusua bia kekesa adehye busua no ehye ohene bia se na ohene no so ono nso so akire ohene bi ti asem we say na eda ho ketu abisa no betimi akopi otumfo anim because in time say that
I'm so much people bureaucratic procedure no and nobody called the legal
number one, prestige or new traditional experts. Into Samupa, so no Bejina, who say will be Bisano Kama no prompt you be. Because we're legal experts, we are looking at the legal aspect of it, not the traditional. When you traditional expert and see, yeah, the no tradition more, he won't go there with you because at that point, it become his opinion, no bit in Yama. But when you're the no legal there, he can give us his expert opinion and he can even quote case files and laws and but on your traditional experts, intimacy. Yeah, my questions law related. Now, the best out of this conversation. So, yeah, traditional once in a while, mean a traditional form of Baby teaching.
Okay, then I think.
So, Ubisa question, I say, I'm fine on two on.
Yeah, okay. Yeah, sorry, man. Manhyia say, hey, I was surprised that one way be away. I say Accra House of Folk, Omunya case before court na judge ni bisa say, he used to buy no I did nyakopo ba bisa dan say hina na edi duaba no. And I was like, oh, omutimi is so religious way etimidi efa asem wo court. What about if some for no me pepe for how would the judge behave? I'm just curious.
Now one guys people need to be Christian.
Christianity who's a Bible near Christian for then as I didn't know Bible. I don't know say the same thing.
Say one guys people for to me Christian a Christopher and people for baby.
I'm talking like I was like, what if these people were Muslims? What would the judge go to say? I don't know if how would it be at court with an illegal way, you know?
Mama answer. When the judges are giving their rulings, in terms of context, in terms of religious context, for instance, we people near Obenya where's
okay.
So to judgment or judgment okay.
Yeah. Well, they prepare before they come, but definitely, yeah. Matthias here.
Oh.
Unse sakris ni
Breaking.
say the network. Oh. Akosua I feel there. Na me brief na me share.
I feel they better.
Unse sa case na Justice Kosa e kan ho asem. Say law school na say lawyers no and lecturers no omo rules of natural justice. And in the first case omo court.
Oh, okay.
Because a clear explanation of the rules of the authoritarian party. A clear explanation of it. So, omo quote you ya na omo sa show Abuaje versus Ghana Commercial Bank. And also chira say, undimi kan chere me say, wafa kwan bia so ATM side. So let me brief the case of Abuaje versus Ghana Commercial Bank. Justice Bamford Ado, Manhyia time Speaker of Parliament, on a mass ruling. So Abuaje was a worker of Ghana Commercial Bank, and now I'm finding some irregularities against him. So what happened was that GC before a query, and I can't query, I won't query. Edman is responded to the query. With the charges now, I say with the possible violations of Mufisi committee. And on also responded to the query. Now responded to the query, the answer now at the moment. And on fan say we in one to Omokosu Kuyini, Omokosu Yinedi. So Abuaje went to the Supreme Court and he told the court that query now the man or responded, it does not constitute to proper right to be heard and now official right to be heard. So my lady Bamford Ado was clear, say because the right to be heard a sacrosanct na a constitutional imperative nintino. Untumi mfa kwan bia so nka say me de tie nipa no. Nti awosanka omote committee na omo level charges no against him. Na omo man kwan na say our lawyer, the lawyer never no be kan asem. Na omo wi a omo the ruling na eden aba. So from that time we start ruling we shape all companies, a shape many institutions. Nti Ghana ho de enu na institution bi wona say pese bi wadi a omo do fa disciplinary procedure mu no. But what them no first na de na etumi fa kwan bi asoka say say me bisa we you want it means say we have heard your side. But this ruling came to shape a lot. I think 1993 or 94 Mubako and GDF I think 19 really date but say Akosua the first chief justice the time, the first chief justice of Ghana at the time. And I BBC here. And in a nutshell, the making in say the court has been consistent. Say unya bo bi kwa du pe. The way there is say unya bo bi kwa du pe. Say nipa na ye bibi say ya. Also man nipa no the proper means to defend himself or herself. So one man nipa no kwan amane defending no in a proper way. I didn't know why you nyina no nullity e be dwuregu. Nullity. Nti AbusuaPanyin so die omo na omo trigger as process no. Nti omo na omo di nkan ball no kwadu. To the moment what triggers our process no, I was saying rules of natural justice no.
Fair hearing.
Into a man kind of fair hearing. So must have fair hearing a year juma. Woman ample time and a show so woman ample time will be to crack out so yari. Any piano Akosua in so yari. Won't say you can't tell say change fair hearing no. Into so crown at fair hearing I say how much more
yes
who now also wait to know one yama fair hearing means yeah Una also wait to know. Una fair hearing. Now that any panel also wait to know the one man fair hearing.
Or him to all the emotions in the near one.
Una what you let us say wait to know. Uno the amount fair hearing because also yari. Yente o side nti yentumi proceeding ko ebibia nti o yare ande o de yare e de ma ohun to wa na waba
So the yare.
ohun to wa na ba but obi a ono wusu wetumi no de obi a wusu wetumi no ominia ono de one man fair hearing court betwem if all these things are brought to the attention of the court ebuphobia court be gina to dey twem no
It's serious.
AbusuaPanyin there, AbusuaPanyin Brefo there, he is a nullity. A quite fast palm there, he is a nullity. Don't you see as an alone?
If you operating on the AbusuaPanyin, echo court na court, to omit me abon Kabi and I omit my man warning, say more yes, but didn't know yes, sir.
No, so when the court gives an order, after that order, they want to be friend with AbusuaPanyin. Unless he appeals it. Unless or appeal, MIP overturn.
But I think so impersonate.
There be say not to make a impersonation because on
someone told very Brefo so now
also feel say a process no. Na make say no ono so dibi mo Tupac sutu edibim. Omu mienu nyina no omu feel say omu ya rightful AbusuaPanyin fo. Then make say Brefo letter no so no untumi ka say o to atwene. So on also feel so AbusuaPanyin because on free say Akosua hene na esi na AbusuaPanyin. Any opinion AbusuaPanyin Brefo so free say ono da ho AbusuaPanyin because obi amfa no mbo no kwadu onim ne ekoso. But me position on the law ne say AbusuaPanyin Tupac be din konim because sa rules of natural justice ne fair hearing anya adwuma. Anya adwuma no so de e be dwiri bibi egu.
Question about
Kings.
See, AbusuaPanyin, ono de ntamkesi ato hene so, eno hene no etu no, menka ne sa, na akọ court, eja mon emrenim fuei. Na AbusuaPanyin na catch court ne say, as far as can natural justice asema, as far as ono ya aware no. One ohene no ene abusuafo ni bi wa asem wo tumfo enima eda ho ayenkan enti antel sesa nsenkaye no yebeka no it's not fair on the part of the court to pass any justice so jurisdiction can the courts consider that before making any pronunciations or judgments on the case?
It's a very good question. It's a very good question. I will say the lawyers of AbusuaPanyin Tupac na some here tactical. Say on the processes are amamremu the first two AbusuaPanyin kokon masamwa. Brefo betumi evoke sadie no. E basa court between no because court no ebia obey na adwin say ende sadie a yenti de be free men share. Timeno dear me nyankombe ne say sa nullity na ma committee na na also maka ho asem. So they should challenge the locus of AbusuaPanyin Brefo in court. And challenging the locus no letter na no ekuta no kire say no na intino oba say bianca oba no proper law man ka beka say no na ye co-warranto your instrument of office, what shows that you have the power to do what you are doing. Tibanka elevating the proper legal sense as an ebekano. Tono ni co-warranto no letter na if you pakosi ho and kuta na man to me so AbusuaPanyin. Inteno na was more tackle. Na omo ebisa ekwan a na pakosi hen fa so a to Tupac. Then the issue of nullity no ebebem. But oko can say amamremu AbusuaPanyin akonya ofie ho nti to AbusuaPanyin na e wo say na now na wo kwa amamremu no And also, no, the question I think is a very good question. We be bet me raise it. No, I can say I said no, can I copy you for an Indian chairman, Yera, no one can na him yen. But all the knowledge, all the point of law, no mukwa. The court will declare that purported instrument as null and void. The court should declare a null and void. It means I did be a peer from my baby a instrument of Brefo and I know see a null and void. So in abolition, whatever happened be a null and void. So the matter will fall back to its normal sense. AbusuaPanyin Akosua and AbusuaPanyin. So they have to be tactical. Thanks, Nyamisha, for this question. It's a very good question, Pan Wibisano.
Receive a follow-up question from Kent there. We say, Edrusa, a judge in the Betimia, a Cobanesa, judge in the Betimia Castle, any, say, as I'm not good drew, Manhyia, the Manhyia, and Castle. In that case, no, court in the bed was no. There now say or move to Ashadana or Masaba so after Manhyia Casano.
Yeah, so the court can adjourn Sinidi. Sinidi nature say we adjourning indefinitely. Pending the Akosua Manhyia.
Okay.
Into the main person you be say the customs no with law no. Okay, me say the customs with law now. The court can decline the rejection. Court in Bekato say on your court of customs nanama tenkunya any the custodian of customs into the be free Manhyia then aba. If for instance akwa say they no be bisa question I think Shamu or say Koba say court declare say I Brefo appointment no in breach any law bia. So Brefo AbusuaPanyin Tupac any the local standing to come before her and Ahima. And that's Koba say at the end of the day, Manhyia a different ruling ba. Yaka say Brefo krano on AbusuaPanyin na Tupac na AbusuaPanyin. Can it retroactively change things? Yes, it can retroactively change things because no nebasana say yura aka say Brefo na AbusuaPanyin na then that means say yura the amamre ni amanye na aka nasem. Then no sa no ubeko court. Na wako set aside the judgment of the judge and now ube appeal and now ube evoke the supervisory jurisdiction of the Supreme Court. I'm a Supreme Court akwashe ni a judge ne kanye because with that evidence na free Manhyia no. Because about what you say. You know, Kens Nyamisha in fact.
Other thing they say.
We break back. No, they have to be tactical. They have to be tactical.
Me other thing they say. Me pacho when they say.
Na me say Maria Majuma be it in the messy form na job be
na who see from say.
I think said the okay, but
my other question is say Judge can say me heard the Manhyia. Can they I know someone to me for the court no but they can they suggest to the court and say on for expert na traditional expert instead say omobeka say omo anjani case na actually the Manhyia beka.
Say the issue of expert no and the expert witness here. We now hear plaintiff and I want to defendant no. We no say o request here. I want what's our request. Now utumi kawasem. The only time a court bit maka say or onwa supina expert witness whereby no your evidence is at par. Say when which mama evidence mu do means which mama evidence mu do. Say am court na confused. Court ni hu yonye. Wo de na waka no emu du pa means ndi amaka ni mu du pa. Then the court will say yemfa independent expert witness emanimra ti ono no beka it will convince the judge say okay any wo beka any A de ne say and any B de ne say inti se court beka say yemfa expert witness ba sa circumstances no ena ya na etoda say a rechi ama court ne kasa Hence, I dare one be case, court on your case, ma'am. And is a way to do such threshold, no. Ebema court na confuse her. Court on for expect with December. Into here, in Pemberley, in criminal trials. In criminal trials, na most in the prosecutions no, and prosecutors no, or more the expert witness ebapa. Because say expert witness ne be mu a bomb to prove case beyond all reasonable doubt. Say be more say no me do. But at the time a court no because of okofa expert witness no, na whereby prosecution as mo kind no, in a cre. However, so no accused no defense no as mom kind no, and also no crepa. Then the court is confused. Court no person who no cry war assembly that one potim. And the side yama independent expert witness emra. Now omeka ni party. Obeka definitely ni obeka no ebeko e na se beku bi. Definitely ebeko e na se beku bi. So that is how it works.
That's a prestige. No, me say because when some men share there, obi ntimi man a deadline. Obi ntimi share men share say, Mr. Asemi friend and term na ye information ni dia ye there. And then next time it is so too for crackers or say be Canada for say World Cup opening na bibisa. Ntimi share na tins Asemi the ebe check.
And I can't say be keen. To one who was an obese residue objection now. And I won't say obese account and as all find the king second again. I bet you.
I bet you.
Then I'm because I can't say be keen. Che. When I can all confessa a mamma never can a court. Hey.
I bet you because Papa no the schedule you booked until so on 1 year ready no so cast answer na and a beba. When you're ready, Diane,
And here as so dear. Well, to me, in an animal for your mom to me, Akosua. Akosua, now, him say, for instance, say, we be crana say, for Abia, when they send a year gun for a case of free music, to me, pay to me, and sister, but I said the free music. Unim say, oh, yeah, all those gestures against a chief, are you to meet you? I was on him, sir.
yeah, true, police station.
Unim say, who did you do in Atama to meet you?
Wait, police station, I'm not working.
Yes, my main job be provisional. And I am for no more to you. If you teach chieftaincy act now, section 63, section 63, A, B, C, D. But the D need the Supreme Court has struck out. Would you be unkind? Wow, but me be a kind. So, but me be a kind, mamma. Section 63 of the Chieftaincy Act 2008. Say, who did you on here? Temwa, a chow. Na D part, na dear, na and only whereby on here for say bra. On here two for say bra, that's a one bar. And on the first, no police to meet you. But Supreme Court has striking it out. Case out, the striking out in me. The case of Nana Ejiampofu versus the Attorney General in 2012. Now on Hinibi or Gosu, near friend Nana Ejiampofu. Or the court say, some provision now was section 63D. No, a criminalized failure to adhere or failure to attend the invitation of a chief, no, is unconstitutional. You know, you can't be unconstitutional. I did be any constitutional boy, into no oivoku article 14 any article 21 who's article 14 kasafa personal dignity home say into a hono in a say you cannot detain someone for more than 48 hours. Article 14 no near kafa on tete wo nipa no personal dignity. In article 21 also no and also kasafa your freedom of movement, freedom of expression, freedom of association. So he went to the Supreme Court and told the court that section 63D of the Chieftaincy Act na say on any foreigners one by police to meet you no. It is inconsistent with Article 21, portions of Article 21 and also portions of Article 14. Because say chief on any frewa opa and obeko. So what if say omo any excuse say oh ya intino beba and also police ba bechiwana. So it's against your personal dignity. And Article 21 also say freedom of movement. To me for some say chinchina oh teacher me say oh mama kwama me nya dia me pese me like me nante to me nkyerem bebia wo se me fa aha man kan to me nkyerem bebia wo se me fa to me nkyerem bebia wo se me ko sa freedom of movement no and on a sacrosanct however and also exceptions and also exceptions so I can say law the exceptions sa freedom of movement and also exception a business say when there's an express law or when there's an operation of law to say baby or ya trouble no entry by order it's called an operation of law.
Akosua PC get the networking come and why
what be a medal semi fresh am person be kan
I am pay baby say ba say ba me atiase patcho kinkan
bro. Akosua section 63 Chief Transit Act 208 section 63 no A no or say act or perform the functions of a chief when that person is not qualified to act. That's A. B. Being a chief, assume a position that the person is not entitled to by custom. And I see knowingly uses disrespectful or insulting language or insults a chief by words or conduct. And a D, deliberately refuses to honor a call from the chief or to attend to an issue. And E,
can see one view.
see what I say. Knowingly uses disrespectful or insulting language or insults a chief by words or conduct.
But 21 Akosua un say yeah mami your sister Queen ma say anka na tepa hene case anka no be che ne pa. So
I think some matisa wakoyo ana maso na kame
opa ojache
Inti just na wuchire ma na chesa ahemfo asemi ba e kura no omo timi I do omo dwuma wa apusu na chesa ahemfo yi kase omo no omo kono pepepe de a ne ebachi nipa
police bet you straight Ghana man bebre police bet you
This is
straight
but man can air for no.
o da kan ni na kan mala chokai
Akosua or say deliberately fail to follow the right procedures to distool a chief. Deliberately failed to follow the right procedures to distool a chief.
Na chese metie no na sia yemfa ne se AbusuaPanyin Tupac senko yo hene
Good.
senko yo hene nanka ekoba ne saade ne nka nipa bedam ensam baby o
na me kwa no see no or say gestures by also conduct nti ukra o catch on hene o don say bibi de trese o maame eyi no o de ye bibi kwa kire on hene e Ghana ko tuma police show
Allah
omo betena social media so di ahemfo atem no nso omo nim mra we nso people don't know most of our laws so they do things anyhow ti nananuma trankunyo omo otumi nti di no na Supreme Court has strike it out as unconstitutional in the case of Nana Eje no your God so hini o
God's my hene. Yeah.
Nana Eje ampofo onim no
Yeah, God's my matin kama didn't know that.
Ono no do call say we say chieftaincy act no e ka bi mo de nanso ade we de violate article 14 and article 21 and no na ma ohene frɛ wo to because wonko ntente de me ka say ko ba say nana no mo won kan frɛ Tupac wo Tupac ka onko I think some kind of different
Yeah,
platform.
okay, be sir. Yeah.
Obit make say on call. Umuntu mi yanehwe. It's because of this Supreme Court ruling. Ti akwahye. Ti mesre. Nana no atrankonya. Omo otumi o. Nti unse yana se yera ebetena se na se yera kasa. Yanko font ente ase yi o. No pese omo de ye sebi impredo so no. On pese omo kasa by heart. But nana no munim emra ni tumi a wo mu nsemu o. Unja fe de enne maybe mu na mu hu tumi omo.
Man for bedemo, a man for bedem.
No, answer na emrana yo Ghana no I chieftaincy art no e protecting na nanama trankunya nti wo de office nti nanam no omo ye good ene nsem nyina na omo de ko omumu ankankofo bebre dem
This is my mother man dey Akosua asem bia Akosua ka ye nkura no na communal labor ya ma mama nkwa de be from kwa himfie
Eno no ne die otoboni nua mimi so nsembe
ya Akosua communal labor to din ya boda ru say ye kododo se bia ye si toilet ye kododo ho
Sobani nua
Akosua na Akosua
ada na woman massa Akosua inside oh
ini bado kura fanchame o fanchame o mimi so amano nende
How
about the same sister Penny?
I don't see what Akosua also refuses to take communal labor announced by a chief without a reasonable cause. That also can home.
Na chese nanamnum sumo nkododo na de oso wado haso de nsemi na ase wo nkwa wo bede.
No need reason bia.
Senior precision bezem busa some kitwa view pacho.
Pacho mti wakra.
In the case of Akosua Hinidi, I fancy Omato Safre na Ose Suso Yare. See also Yare. They be a some count one day be na Yura, sorry say. I try as a baby you are no mighty. Miama Kumia, my Jima Kumia. But two in his absence because was your friend or ma. Obey to me the era and that's what they between the Manhyia court say Yaman natural justice or me in one you are new kinds of Jacobian free in some manner.
But you obey to my court so obey fairly because on to me improve say there's an absence of audio terrain pattern and a natural justice because you better time one your tones are friend any the number of times are went to me on that and untina a na echeno nze nana no person ma ample time na one koka say yintie wo side court bia so ni ho a wo koka che ne say ai omotunza friend be mfie mienu be afi baako na me yare ntibentumi anko a obeji sa rules of natural justice no atum say anya adwuma court bia ni ho but what must say intino yera ebetumi yera ye din na o hwe because opese otie ne side wa mana kunya say omra embeyi ne ho na nananom mana kunya say me say kunya akwenya say omra embeyi ne ho ano ni nyina ye hearing the side say sa right no say we ntu ho anamo na say omani shigu a eso no a this day me can say there's always an end to litigation.
Yes.
Until you to say I'm filing notice of appeal. In today's time, I can go to court. After 6 months, it ceases unless you invoke provisions unless there is a nullity, unless you go to Supreme Court. Definitely no, you have no right of appeal again.
Order 9, but unyan can
Obimbi order 9. Dopo Obimbi order 9 now on kind of CI 16. Sorry, CI 19. Sorry, CI 19.
Okay.
Order 9.
It means senior means Pakosu de Nambusa like he has no case. So between I said I can be a bit me court, but say obedient
because also prove say yama of fair hearing. You also prove say audio term party na nyejuma. Ube dey prove because on make a judge and say ye tonsa flow afi baako when one ma judge ni few kra afi baako no be mo few kra enti na yera sanka yera otumi say ma flow baako na say one by ho no two but ono pa asantema ye ne dia mira me ye nyina ye som no nso no go dey mra ye adwuma how much more sebi yeah sebi imperial so we dem use as a figure of speech ye nyi obia na say ye kra na we say ye di mra no so ko abro ye raso like you say ye di mra no so more than ye kra person ye di so say you to me di mra no so bro like you respect law no more than anything.
Apesi bacho we senior bacho won so be the era na mention akokot da visa rudi mrachi. Say ye ran kasa pa there be me hu ye but asan to be corrected but paramount chief there be breko nana do man he say ye dey no court and I but ye ran kasa and they asan to be corrected ye ran kasa
Akosua we kwa the sans review
ye ran kasa de onu di denche ye ran to me fa no court no na ye ran kasa o kan sama court bia entumi ensesa na no. People were trying to misconstrue what my Lord said. People were trying to misconstrue what my Lord Asantehene said. Yera said. Opposite china will say, "Ono na answer na send bebo beka no. Or the pepe ne kre ene mra ene amane ene amamre ne beka." So can we are to me enkasa o de court. Wa kra no unya grounds na o de akofale. You see, in as much say anybody can go to court, no, there should be grounds before you can win cases in court. Say, file rate, that's a rate, no. Say proper grounds in Nimua. The court will strike it out as incompetent. Say, incompetent, I'm not say rate in Moha. And your rate, a dim way was a bammy.
So that's incompetent as about me.
Oh, Mr. Yanko politics.
That be na minim sending out shit.
So, intino, kokota, unya grounds. This are grounds, unya. Because Yama, but then Nana Paco saying, say, Yaman infamious, and I stand to be corrected, and I'm a boy. And infamious, and didn't own to me crank kakra. You cannot. You dare not.
Yeah, ma unya ibia sembia nyina so. Na se ofiso ka bibiana.
There be do cat say in film so in film no ne efa 2.5 years.
Okay, but you say in film ba kokra enough. Mira. As I say in film ba kokra enough. Me da se panya mi show. Tino unse answer na yera baby bi no no. King Solomon of our time, Mr. Woody, I'm more fancy and I obi beka say me come asante say.
But don't say because of workers or double ni me or the 9 until would me tell one answer.
Yeah,
Order 9 of CI 19. A court of appeal.
Epa mochewo onse monkotwa lawyers kanso munya free legal education into more power tap ni sustaining life no na mo gift me guess na mo gift me guess we ka mo buy na ke de na funu yire ka mo gift aha so de yen kanesa ti mo gift me guess epa mochewo na mo power tap why eno pe na hia
but so na mo follow Akosua ti why
bedase I had a nye ba ku bi no me funu yere na lion no su Mr. Woman gift to
me data force for no so me president e wa Akosua ya boa
Prestige.
Yeah.
About no one need be kind or tamano.
Pacho you.
No question be okay is no about CI about traditional rulers no say gestures cry no ko ye gestures chiro henia otimi si wo wow we dey that
Otume a crime. Any see you cry crime. into MMA we ready although Bruni ready and I don't know section 63 of Chieftaincy Act. Now no no A B C desire Ekosi I think E or F bisa but baby say any juma bi a D no D no de no na ka say on hene to nsa fro na say one ma and no na first na nka your offense but obi de court ama court e declare say and no de e null and void nti D ni nko na enye adwuma sese ba nya ka nyina na ye adwuma na wonim say nananom no eya no omu hu ye say ye omumma ye no nyina na omu take it to heart and can go for bebrebe dem
Mepacho, the oka and a man says you'll be repeating your mama me. O question and the answer, Nina, Mepacho.
Mepacho, one me.
Aye.
I prestige. Nana me banana nana ase me follow the partner me dragontina. No, the material says prestige chim say sebi timamu fro oye gestures says sebi ukokrumutino yen say the catch or hine said the ma missing na nina nimsina a liable offense a criminal offense a offense na me nim da say constitution mu na the name question sub question number 7 to also say and that say prestige your Ghana constitution no a unique in its own in the sense that say your mark traditional rule is so much power and
Mamika Bibinchel before democracy ebeba no na nananom na edigana so na ye migrated from democracy ye migrated from traditional ruling na yaba democracy mu no enye nananom na omoma ya futu a nke yentumi mba and ntide nyina ye yadwen say ye chieftaincy institution ye be protected and only your backbone and only your bedrock evidence back ni emra intokwasi e wo sire mu no Rollins awe ne bebuko wentumi ansolve kufuo yera kufuo wentumi ansolve John Mahama number 1 wentumi ansolve Akufuado wentumi ansolve ni obe solve problem no eye yera Asante Kotoko hene. So you see how your chieftaincy institution are precious. Tinyina ya doing say you have to protect it and preserve it. Now only your constitution ni mu a ohene enya politics, ohene active politics. Yenim denti aka say ye ma ohene nya active politics. Because ohene ya active politics a ebema chieftaincy institution no ebema enim ebema aye disregarded to be a onfe buoma chieftaincy institution no enti na say ohene enye politics no tiene krampo chira wo say ye pese hold you in high esteem timi krampo de wempo de eye nenketwa osanka ye de mra no kra hyemu mo we said Akosua but the only unfortunate thing is say ye be jelu 3 months pay ana ye be jail ana ye be final 200 penalty unit one penalty unit be also I think 12 cities or so multiply 200 by 12 I think 2,400 right bibisa intino ye jelu 3 months mimpo de na mpesa nka ye more than a year but the framers of the chieftaincy act ni hu ni say ensheda anye yibia nto de anye hwe say na be ya be man nkofo edi buama nananom ahemfu two kind section 63 na ewo ho ni nyina wo ho.
Okay, President Manya, time limit of appealing. Time limit for appealing. 1. Subject to any order, enactments for the time being in force, no appeal shall be brought after the expiration of A. 21 days in the case of an appeal against an interlocutory decision, or B, 3 months in the case of an appeal against a final decision unless the court below or the court extend the time. Number 2, the prescribed period within which an appeal may be brought shall be calculated from the date of the decision appealing against. 3, an appeal is brought when the notice of appeal has been filed in a registry of the court below. 4, no application for extension of time in which appeal shall be made after expiration of the 3 months from the expiration of the time prescribed by the rule within which an appeal may be brought. Then 5, procedure 8, you can 18 now.
Can do 7 no.
7 no, okay.
Baby, I hope I 4 and 7 no.
4 and 7 no. Okay. 4 no say no application for extension of time in which appeal shall be made after the expiration of the 3 months from the expiration of the time prescribed by this rule within which an appeal may be brought. Then 5, an application for extension of time must be supported by an affidavit setting out good and substantial reasons for the application and grounds of appeal which prima facie showed good cause for the extension of time to be granted. Then 7, where the extension of time is granted, the notice of appeal shall indicate the date of the grant and the judge or the court by which the grant is made. Then 7, notwithstanding Rule 28 of this rule, no application shall be made to the court for extension of time within which to appeal after 6 months from the date of the decision appeal against.
Say with you, what you say?
Self-explanatory. After 6 months, no dear.
After 6 months, ne dear me pacho lawyer baako pe and was here Bempomaa me exception. Was there an exception? Yes,
I repeat you. Also, notwithstanding Rule 28 of these rules, no application shall be made to the court for extension of time within which to appeal after 6 months from the date of the decision appealed against.
So section 28 na then oh.
Oh, and they be reading Rule 28, no, they could read Rule 28.
Okay.
Rule 28 I casafa interlocutory decision, but the man could read it. Say be a file court below na say inti or the man could read it.
Yeah, all right. Okay, Rule 28. Court to which application should be made. Subject to these rules and to any other enactment, where under any enactment an application may be made either to the court below or to the court. It shall be made in the first instance to the court below, but if the court below refuses to grant the application shall be entitled to have the application determined by the court.
For instance, Oko court below na say o refuse cry. You say they we refuse and I say 28 you can take effect no extension will be given after 6 months. To the no matter the nearby so after 6 months a trim my heading a trim. And this will be there 20 me checking as a May 28th and then my lady Emma ruling our high court. So after May 28th kind from that time to 6 months, which may be sorry, November 28th, and my lady ma ruling me. So okay, from 6 months, from November 28th, and that's about to May 28th. Ti ma mention your person can now or deny one. So I say assemble so person who appeal. We didn't file notice of appeal. Now notice of appeal and conforming TRT say so far as our filing notice of appeal and anytime they to me.
Senior number so because when you notify court it means I think the amount anytime you can take up to even a year, you can appeal anytime.
Me pacho utu amount ben. The court process is simple. O file will be o prepare a rate we are now o call court registry. I want to process ma utu ya na yama date into okokuchie catering here na each was anko. That's how it works. Into court say kwan say no man I think Zenith Bank they control.
Mr. Hab team you.
Zenith Bank they control payment. So I read this all quite appeal. Not so call ya.
Atamoja minu aba no ase.
And one say bia and then a person of fire oko fire your money is with you.
What question?
Other mammy court registers near BB area, clerks near BB area. No matter directors a call payment center or no kutia. Na oma file na process na kick starting. The notice of appeal na the person change na say o person o kwa appeal e also notify the court below. Just a court na e din kan ka asem no. When I was say o catch on so person o kwa appeal. And reason tia o yes ade ne say o catch on say na be ya o mo be boa document ni nyina no. Na o ma escalate every the registry of that court no and they are called the registry of the court of appeal. Notice of appeal ni no to me nkonko file the substantive appeal abra on your notice of appeal because o ko file the substantive appeal document bena o mo be gina sa na so on be hwe so ntira wo se o din kan boa document na no e o bebi e ka asem nti Kumasi High Court no be prepare document ni nyina na wa transmit and wa ship because wa ship wa o de mama man use wa ship na confusing ko for and wa transmit e dey akwa command court of appeal registry no nti no sa no nya file notice of appeal na the day na judge na ma judgment no o 3 months e wo se o dey sa anyoma no sa 3 months no e also file notice of appeal no sa file appeal no proper but e bia bibi nti se 3 months na ba so na wo hwe na se bia 3 months na mu no untumi find court appeal na no file for extension to file for extension na you be say 3 months asaka ho yes about 6 months after filing for extension ya 3 months account no say 3 months na dey ama account na say no end dia untumi kwa appeal bio and on order 7 na no say no more extension after 6 months. There's always an end to litigation. Tiwana na baba catch say one filing the time be obet mako say nyanko obi betumi a filing notice of appeal na kwa 2 years na nkoko. Oh, it's absurd. It's preposterous. Untumi kanasa. So no appeal after 6 months. However, there is an exception. Exception na much one say when there is a nullity. Say nullity ni kwenda machim. Ebiana emra ye no na emra ye di asem wo court below no. Ebiana judge na ma kwan ana judge no am right to be heard bi an adwuma. Ana ebimpa one notice fraud bi wom. Serious fraud bi wom. Eno na sa ne de ubetumi ejina eno so ama sa 6 months na eye ba no a higher court betumi bie sa ba ne free betumi his have ne free And the be I'm Kevin Taylor some example I say on the entire Supreme Court quite na say because na 6 months na twem I also appeal na twem. But the entire Supreme Court quite na some say there was a nullity. According to Kevin Taylor, no say judge didn't take a side. And of course, who could make a pronouncement in his order. As if said that Kevin Taylor and Kwan would for that. So the moment when take a side, all the other party na anye jumane there, automatically na dey bia na judge na a nullity. Into read the case of Barclays Bank versus Cable Metals. Yeah, Barclays Bank versus Cable Metals. Bibi sa akoso. And my court says Supreme Court akase. Whenever there is a nullity, it can be quashed at any time. So if there is a nullity, and the open 6 months in 2 years, it did 10 years now. If you are able to identify, say there was a nullity, the court will open it up for you and go and quash that nullity. Tina Kevin tell a man acquire Supreme Court quite no, because the judges asked him. I think my favorite judge has to be correct. I think Amadi Sule also, my lord. But me
and semni munche mu ene yakwakojiaba no se say ye twen otumfo de nan asinu na watu gina ye ne de enim se bibia ebetodwa na ye hu se ye busapani to saki obesa ba be ye busapani to park ana se busapani brefo ene bedi ade abusia emeguso kai wo se aha AK Black Media ne de kan media share mesre so be subscribe na wa share ma foforo ensa etumi akabi na waje wadwentre e wo comment section Yebesha once and from Macau.